warahmatullah. How are you today? Alhamdulillah. Hopefully all of you are feeling very well. So actually today I'm going to discuss with you on the chapter Law of Contract. So are you ready? Yes, of course. So under Law of Contract, actually we will discuss the main part whereby it involves contract generally. As you know, contract it involves our daily life. We have so many types of contract. Okay, for example, we have contract of loan, we have contract of marriage, we have contract of scholarship, and the main one, contract of sale. For example, contract of sale, it involves sale of goods, it involves services, and besides that we have also others contract such as contract of employment, contract between partners, contract of agency. So meaning that there are so many types of contracts. For today I'm going to look at on more on the elements actually. So besides that, now have a look on the content that we are going to discuss under law of contract. So for the content, we look at on definition of contract, we look at types of contract, elements of contract, discharge, and also remedies. Shall we move to the next? Yes, we look at on what is contract actually. Do you know what is contract? Yes, contract, it refers to an agreement. Agreement. Okay, next. So now look at what is contract actually, the real definition. So the real definition is it is an agreement made between two or more parties which the law will enforce. It means that it must be an agreement and it must be two or more parties, and it must be also the interference with the law. So please highlight, it involves the law. In Malaysia, yes, in Malaysia, we have the law govern contract. So the law which govern the contract is Contract Act 1950. Please highlight this one. So we have Contract Act 1950. And next we look at on the definition of contract under this act. And we have section 2 subsection H. So section 2 subsection H is defines the word contract. It means an agreement enforceable by law. Yes, it must be enforced by the law. If you look at the contract itself, once you make a contract, automatically it requires certain rights and obligations. You know what are rights and obligations? Yes, rights mean hak and obligation means tanggungjawab. It means responsibility. So you have to bear in mind, once you made a contract, automatically you have your rights, and at the same time you must fulfill your responsibility. Alright, next we move to the next slide. So it means that under law of contract, of course there are two parties. For example, if one of the parties he break a promise, so meaning that another one he would have the right to sue another. This means under breach of contract. Breach of contract means langgar janji, for example, break the promise. However, before he can sue that person, he must prove there is a valid contract. There must be a valid contract. So the next slide. The second one is types of contract. Actually, there are 4 main types of contract. We have valid. Valid means sah. Void means tidak sah. Voidable, it means boleh dibatalkan. It means voidable ataupun voidable. And the last one, we have unenforceable. Okay, unenforceable, tak boleh dilaksanakan. Next, we have types of contract also. Okay, these are main types. Okay, we have bilateral and also unilateral. If you look at bilateral, it means both parties. It involves both parties. Both parties means promisor and promisee. So whereby both of the parties, they promise to do something. For example, in the case of sale, okay, selling and buying. Okay, I give the example here, buying a loaf of bread from the bakery. So it involves the seller and also the buyer, whereby the seller made the promise to sell and also the buyer make a promise to buy. So it means a bilateral, okay, both parties. Next, we have unilateral. For unilateral, it's different with bilateral because unilateral only involve one party. Okay, whereby only one party make a promise and another one, he just perform the act or the condition. Okay, the best example is finding a lost cat. Okay, for example, it involves a reward whereby if you look at this example, it's about an old man. He made a promise to give a reward for those who find and return his lost cat. This is a promise, okay, made by one person. Okay, how about another one? We have this guy. He find and return the lost cat. So meaning that this means a performance, okay, performance of the act. So there is no promise made by that guy. However, under law, this also can be considered as a contract even though it's only involve one promise. That's why it is called as unilateral. Alright, can you understand? So let's move to the next slide. Contract versus agreement. Yes, please look at this statement. All contracts are agreements, but not all agreements are contracts. So it means that contracts are agreement, for example, whereby it involves a seller and also a buyer. Okay, a seller and buyer, it can be related to commercial agreement, for example. But if an agreement made between a father and a son, for example, maybe a father promised to give his son a car, for example. So if the father break the promise, so meaning that can the son sue his father? Okay, under the law, this cannot be considered as a contract. Okay, it's just mere an agreement. And how about the seller just now, a seller and a buyer? If one of the parties break the promise, actually under the law, it may amount to a contract, meaning that one of the parties who break the promise can be sued by the innocent party. Okay, so that's why we call this as contract. All right, let's move to the next slide. The next slide is about elements. Okay, before we can say a contract is valid, we must fulfill all these 9 elements. Yes, all these 9 elements. So we have offer, acceptance, intention, consideration, certainty, legal capacity, formalities, legality of object, free consent. Okay, so that's all 9 elements. Okay, you have to remember this one. So now we will look at on the first element, that is, yes, offer or proposal.